Most people who get arrested at a traffic stop were never speeding, never drunk, never had anything illegal in the car. They got arrested because of what they said and did in the 45 seconds after a cop looked at them and said 4 words. Step out of the vehicle. And here is the brutal truth. Stepping out of that car without saying exactly the right thing first is the single most expensive mistake a driver can make. Because in those first 45 seconds, before your feet even hit the pavement, you can either lock every one of your constitutional rights into place, or you can hand that officer a legal roadmap to search you, test you, detain you, and arrest you, without ever breaking a single law. 4 rights. 3 phrases. 1 moment you cannot afford to waste. By the end of this video, you will know exactly what to say, word for word, the second that order comes. And not a single move I give you will require arguing, resisting, or raising your voice. Everything here is grounded in 4th and 5th Amendment law, Supreme Court precedent, and the tactical framework officers are trained to exploit the moment you step outside that vehicle. This is educational content to help you understand your constitutional rights. For advice specific to your situation, always consult a licensed attorney in your state. And if this is your first time on this channel, subscribe right now, because the next video covers what happens when the officer claims he smells something, and the phrases that work in that moment are completely different from these. You need both. Here is what most people do not understand about. Step out of the vehicle. It is not a request. Under Pennsylvania v. Mims, the Supreme Court ruled that a police officer can lawfully order you out of your car during any valid traffic stop, no additional justification required. The court decided the officer's safety interest outweighs your right to stay seated inside your vehicle. And a few years later, Maryland v. Wilson extended that exact ruling to every passenger in the car as well. So let that sink in. You do have to get out. If the officer demands it, the law is settled, you comply. But here is what the officer is counting on you never knowing. The moment you step out of that car, for things are set in motion simultaneously, and every single one of them is designed to build a case against you before you have said a single incriminating word. The first thing that happens is the officer now has a clear, unobstructed line of sight directly into your vehicle. Anything visible through your window, a bag on the seat, a container in the cup holder, anything, is now potentially subject to search under the plain view doctrine. He did not need a warrant. He did not need your consent. Your stepping out gave him an angle he did not have before. The second thing is that once you are standing on the roadside, outside your vehicle, nervous, with traffic passing behind you and an officer studying your every movement, he may tell you he needs you to perform field sobriety tests. Walk a straight line. Stand on one leg. Follow the pen with your eyes. And most people simply do it because nobody ever told them those tests are entirely voluntary. Every court in this country recognizes that. But officers are not required to tell you that either. The third thing that happens is the Terry frisk. Under Terry v. Ohio, an officer can conduct a pat-down search of your person if he has reasonable articulable suspicion that you are armed and dangerous. That is a specific legal standard, not a general feeling, not a hunch. He needs an articulable reason. But once his hands are on you, he is not just checking for weapons. He is looking, he is feeling, and he is building. The fourth thing, and this is the one that destroys the most cases, is that you start talking. Officers know this. It is the primary reason they want you out of the car in the first place. A person standing outside on a roadside, uncomfortable, anxious, hyper-aware of the body cam, starts filling every silence with explanation. Officer, I didn't do anything. I'm just coming from a friend's house. That smell? That's not mine. I maybe had one drink earlier, but I'm totally fine, I promise. Every single word is evidence. Everything goes on that body cam. Everything ends up in a report. And officers are trained to be friendly, conversational, and completely non-threatening in this phase, precisely because they do not want you to realize you are building their case for them in real time. So now you understand what the officer is doing. Let us talk about what most drivers do, and why both responses destroy them. The first driver panics and complies with everything. Step out? Of course. Field sobriety tests? Sure, whatever you need. Search the car? Go ahead. They believe that total cooperation will make the officer move along faster. It will not. Every voluntary action, every answered question, every test performed is another layer of evidence handed over without a warrant, without probable cause, and without any legal requirement to do so. The second driver refuses and pushes back. I don't have to get out. You can't make me. I know my rights. Now the officer writes down that the suspect was aggressive, confrontational, and uncooperative. That language goes directly into the police report. In some cases, the officer may argue that the refusal and the behavior gave him independent grounds for further action. Neither of those drivers protected themselves. Both of them made the officer's job easier. And here is why. Because both responses handed the officer something he can use. Total compliance hands him evidence. Confrontational refusal hands him narrative. What you need to hand him is nothing. So here is exactly what you say. The moment the officer orders you to step out, before your hand even reaches the door handle, before your feet touch the ground, you say these words calmly and clearly. Officer, I'm stepping out as requested. I do not consent to any searches. Am I free to go, or am I being detained? Say it calmly. Say it firmly. And then stop talking. Let me break down exactly why every piece of that statement works the way it does. Officer, I'm stepping out as requested. You are complying with Pennsylvania versus Mims. You are not arguing, not resisting, not giving the officer a single thing to write down about your behavior. The body cam sees a cooperative driver. That matters, both on the street and later in a courtroom. I do not consent to any searches. This is your Fourth Amendment invocation, said out loud, on camera, at the exact moment the encounter escalates. If the officer searches your vehicle or your person after this statement without independent probable cause, everything he collects becomes a suppression argument. Your attorney can challenge it. Courts have thrown out evidence in exactly this situation. Your verbal non-consent, spoken clearly and recorded, is what makes that argument possible. Am I free to go, or am I being detained? These words force a legal declaration. The officer now has to make a choice on camera. If you are free to go, the encounter is over. If you are being detained, he is required to articulate an independent reason, reasonable suspicion beyond the stop itself. Either way, the legal burden shifts back onto him. You have done the only thing that protects you in this moment. You have said the right words in the right order without giving him anything to use. Now the officer is going to push back. He always does. Know exactly what to say when he does. If the officer says, "Look, I just need you to do a quick sobriety test, and then you're free to go," you look at him calmly and say, "Officer, I exercise my right to decline field sobriety tests." That is the complete answer. Field sobriety tests are entirely voluntary. You can be completely sober and still fail them. Lighting conditions, uneven road surfaces, anxiety, medical conditions, all of these affect performance. No court can compel you to take them. And declining is not evidence of guilt. Say the words, and stop there. If the officer says, "If you've got nothing to hide, just let me do a quick search and I'll get you out of here," you respond, "Officer, I am exercising my constitutional rights. That sentence is legally bulletproof. The invocation of your constitutional rights cannot be used against you as evidence of guilt. Every court in this country has been explicit about that. It is not suspicious. It is not incriminating. Say it calmly, and do not add anything else. If the officer conducts a pat-down anyway, or begins searching your vehicle after you have clearly refused consent and there is no probable cause, you do not raise your voice. You do not touch the officer. You do not resist physically in any way. That is the trap. Officers know that physical resistance or verbal escalation can be used to justify an arrest for obstruction or resisting, regardless of what else is happening. Instead, you say again, I do not consent to any searches. Say it for the record. Say it on camera. And then you go quiet. Because your fight is never on the side of that road. Your fight is in a courtroom, where a judge will look at body cam footage of a calm, compliant driver who clearly invoked their rights, and then look at what the officer did next. That contrast is the foundation of every successful suppression hearing. Here is what changes depending on where you are. In Illinois versus Cabal, the Supreme Court held that using a drug detection dog during a lawful stop does not violate the Fourth Amendment as long as the stop is not unreasonably prolonged. But Rodriguez versus United States drew a hard line. The stop cannot be extended beyond its original purpose just to wait for a dog. Every additional minute you are held after the original mission of that stop is complete is a minute the officer must justify with independent reasonable suspicion. Ask every few minutes, Officer, am I free to go, or am I being detained? Put it on camera. Keep the constitutional clock running. In states where marijuana or hemp is legal, challenge any smell-based justification directly. Hemp and marijuana are chemically identical to the human nose, and that argument has succeeded in suppression hearings across the country. Know your state's law on odor-based probable cause before you need it. Before any of this applies, control the first 30 seconds before the officer reaches your window. The moment you see the lights, pull over immediately and safely using your turn signal. Turn on your dome light if it is dark. Kill the engine. Place both hands visibly on the steering wheel. Lock your doors. Roll your window down 2 to 4 inches only. When the officer asks for your license and registration, say calmly, I am reaching for my documents, and then pass them through the window crack. Do not open the door. Do not roll the window all the way down. Do not give the officer a line of sight or access he has not yet legally established. The body cam sees a calm, deliberate, cooperative driver. That image matters from the very first frame. 3 phrases. Burn them into your memory right now. First, Officer, I'm stepping out as requested. I do not consent to any searches. Am I free to go, or am I being detained? Say it the moment the exit order comes, before your feet hit the ground. Second, Officer, I exercise my right to decline field sobriety tests. Say it the moment tests are mentioned. No explanation. No apology. No elaboration. Third, Officer, I am exercising my constitutional rights. Say it the moment he pushes for consent to search. Repeat it as needed. And underneath all of it, if anything is found, if you are placed under arrest, if the situation escalates, 4 words end everything else. I want an attorney. Say them immediately. Say nothing after. Under the 6th Amendment, that invocation shuts down all interrogation. Everything from that point forward goes through your lawyer. This is educational content only and does not constitute legal advice. Always consult a qualified attorney in your state for your specific situation. If this video found you before your next traffic stop, it did exactly what it was supposed to do. Subscribe to this channel right now, Because the rights that protect you outside the car are completely different from the rights you need when the officer leans into your window and makes a claim about what he smells, what he sees, or what his K-9 alerted on. Each situation has a different constitutional framework, different case law, and different exact phrases, and this channel breaks all of it down, one scenario at a time. Subscribe. Share this with someone who drives. Someone watching this right now might be pulled over tomorrow morning, and the difference between driving home and sitting in the back of a patrol car can come down to a single sentence said in the right order at the right moment. Stay calm. Stay compliant. Stay protected.